Welcome to Southwest Florida Real Estate Update, hosted by local realtors Jim, Michael, and Morgan York of the York Real Estate Group of Downing-Frye Realty. Our show will bring you the most up-to-date information on the local real estate market, featuring the leading experts in the real estate field.
Hi, and welcome to the Southwest Florida Real Estate Update. I'm Michael York of the York Real Estate Group, and today we're joined by our host, Jim York, and his guest, Don Ross Jr., President of Ross Title and Escrow.
Thank you, Michael, for the introduction. Well, Don, thanks for coming on the show.
Thanks for having me, Jim.
We're here in February, so 2018.
Is that the year? Okay.
That's the year.
Okay.
So, hey, tell us a little bit about yourself.
I'm an attorney in Naples. I am the attorney for Downing-Frye Realty, have been for 25 years, one of the owners. I have my own law firm. I own Ross Title and Escrow. We have 8 employees. We're on the corner of 6th Avenue North and 41. I've done in excess of 25,000 closings. My people have been with me a long time, very nice ladies. My manager 30 years, her daughter 20 years, her sister 10 years, her niece 3 or 4 years, and then we have a few other people. So we have a nice team. They work well together. Nice atmosphere, nice working environment. Allows me to come here and visit you.
Yeah, what I like about them is we can always get you on the phone, and
right.
We can always get the closers on the phone. If we have a question or even an email, they respond immediately, not the next day.
That's because that drives me crazy when people don't.
So
we know people care about a response, and we try our best.
So Don, I guess there's, we have buyers and we have sellers, and we have 4 different contracts that we can offer a buyer or a seller. So let's start with the buyers. What kind of contract should they be using or not using, or let's explain a little bit.
Well, this came up this morning. As you know, you and I had a different topic we were going to talk about, and my wife, who helps me with my articles I send out, suggested some sort of discussion on what I would do if I were selling a piece of real estate, me personally, or if I were buying. The one observation I have, there is no one-size-fit-all for sellers. There's no one-size-fit-all for buyers. It just depends upon the person's situation. It depends upon if they receive an offer that's in excess of the list price and they don't want to rock the boat by using a form they would rather use. It depends upon how long it takes to close and how much of the season they're going to lose. It depends upon how familiar the realtor is with the 2 NABOR forms, the 2 FAR forms. I mean, there is a FAR form, and there are different forms throughout the state of Florida.
That's right.
And I get asked all the time by agents, which form should I use? Now, the easy stock answer I do as the attorney for Downing-Frye is use the one you know the best. That way, they're better able to explain it. They're less apt to make a mistake. They keep track of the time periods. They know how the inspection process works. They know how the financing works. In a perfect universe, they're more familiar with it. It's like being right-handed or left-handed. And with all these different forms we have, I'm sure there's one that you use more than the other and you're more comfortable with. But for buying real estate, I particularly like the NABOR as is. If I were buying real estate, I would use the NABOR as is. A number of different reasons. Time is not of the essence in this contract, unlike FAR where it is, which in English means if I miss a date by a day or 2, I'm not in default. I'm given a reasonable period of time, depending upon the facts and circumstances, to respond. The second big reason that I like that, and I wrote all these things down, is I like the financing clause a lot better in the NABOR clause, in the NABOR contract. With the NABOR contract, the buyer has to waive the financing contingency if they want the contract, if they want to deprive the seller of the ability to terminate the contract. If the buyer fails to waive the financing contingency, nothing bad happens automatically. The seller can threaten to terminate the contract if they don't get a waiver by a certain date. And I usually recommend 24, 48 hours because, again, time is not of the essence. But nothing happens by accident. It has to be an affirmative act where the seller is saying, if I don't get that waiver, by tomorrow at 5 p.m., I'm going to terminate the contract. So from a buyer's perspective, I like the financing clause. I like time not being of the essence if I'm a buyer because it gives me wiggle room if I'm a day late with my deposit or the inspection process. I like the fact that it's as is. Now, as is, in layman's terms, means that I get a free look at the property, and I, in my sole discretion, can terminate the contract if I so choose. I don't need a reason. I don't need to give any inspection reports to the seller. I could have found another piece of property I like better. I could have just said, I changed my mind because the stock market went down or I lost my job, whatever it might be. I have 4 children, so when my kids were buying real estate, I always encourage the as-is because I know their situation.
And that's within the 15 days?
It can be, well, the default period is 15 days. If you try to go beyond that, an astute agent is going to say, what do you need 30 days for? Some situations require 30 days if it's commercial, and then we go to the FAR contract, which is another contract. But if you can explain to the seller why you need X period of time, you might be putting an addition on, for example, and you have an appointment at the building department with your architect and your builder. So if you can give the seller your rationale for why you need more than 15, you may get it. And it's always good to go for it. It sure as heck doesn't hurt. I also like, as a buyer, the risk of loss paragraph. We had Hurricane Irma, and this is radically different from FAR. If I sign a contract and right after I sign it there's a hurricane and it damages the landscaping, the seller has to replace it. FAR, they don't. They prune and remove trees.
That's right.
So there's a lot of things in this particular contract that I'm comfortable with as a buyer. I like the ability to pull the plug for any reason. I also like, and this is the NABOR as is, the first 13 lines are tangible property that goes with the deal. Security systems, home entertainment systems, pool equipment, things of that sort. The FAR has a much more limited list of tangible personal property. They exclude the washer and dryer and the microwave. So, a lot of reasons like that. If it were me, I would use this. Unfortunately, I think more of these fall apart from what I've seen. Statistically, I may be wrong. Other attorneys may disagree. But it just seems that it's pretty hard to avoid knowing that you have the right to terminate using this contract when it says as is at the top. Every buyer knows, so they're a little bit quicker to pull the plug if they're uncomfortable with the transaction. If they run into mold and they don't understand what it is and how to deal with it, and it's a common thing down here, they're a little more apt to act out of fear and pull the plug, especially if they don't have an informed agent and with a team who can explain it to them.
Yeah, well, we use the as-is quite a bit with our clients or customers, and we explain, the pluses and minuses. But my feeling is that if a person doesn't want a house or a condo down here, and they wanted to get out, I feel good if we did an as-is. If they want, I don't want them buying a house or a condo that they didn't feel comfortable with, and they're tied into the contract.
Well, so, you and I get the clients who have medical issues, and somebody who's on chemo, somebody who's just had radical surgery, and things that would be considered, say let's pick on mold for example. If there was just an allergenic mold, but this particular client has just gone through a year of chemo, and their immune system is very weak, we're able to adapt their personal medical situation to the contract by having an as-is contract and give them the flexibility and the peace of mind of being able to pull out if they really are legitimately concerned and don't want to purchase it.
Okay, well, Don, before we go into the next phase of this contracts, let's just take a little short break and we'll be back in 1 minute. Thank you.
Looking for a real estate closing agent in Southwest Florida? Ross Title and Escrow has over 25 years experience and has closed over 20,000 residential real estate transactions. Donald Ross Jr., president of Ross Title and Escrow and a practicing attorney in the state of Florida with a degree in taxation, is here to service your needs. Call Mr. Ross or one of our 4 closing agents for a free consultation today.
Welcome back. Don, let's talk about the deposits. How's that handled on an as-is contract?
Well, again, NABOR treats deposits differently than FARBAR. NABOR, the deposit is what the seller is entitled to recover if the buyer breaches the contract through no fault of the seller. So if the buyer just decides, the heck with the contract, I refuse to do it, and they don't have a legal justification of this contract, the seller's sole remedy is the deposit. And under NABOR, it's limited to deposits paid. FARBAR, it's all deposits paid or agreed to be paid. So in our business, you tend to see 2 deposits, a small initial one, and then the balance of what usually is 10%, unless you get into a very high price range. And with NABOR, it's easier for a buyer to walk away from $1,000 if that's all they have down initially, or even $5,000 if it's $1 million transaction. You know, they can walk if they find something that really concerns them in the inspection and just lose the 5. Versus FARBAR, where the seller can go after the buyer for deposits made and agreed to be made. So again, if I were buying, I would use the NABOR as me personally, but I know my situation, I know my risk tolerance, and I know both contracts, all 4 contracts. Now, having said all that, I would change my mind if somebody was offering me a really tremendous deal. I mean, and it's at the right time of the year. It's not going to take up too much of the season, but if I got the price of a lifetime, but the seller was only interested in using the FARBAR as his contract, I'd go for it.
Go for it,
just so it depends upon all the variables. So that's, I guess, part of the reason I'm doing this is to show to people that there is no one-size-fits-all. That even for me, what I would prefer changes depending upon the time of the year, the amount of the money involved, what the seller is offering to sell it for, or what the buyer will buy it for. If the price is right, sure, there's always an exception.
Well, don't you think, if you're representing a buyer, putting in an as-is, you sometimes get a better price too?
Yes, and I had a conversation with a gentleman from Scotland, actually about an hour ago, and he wanted me to review a contract. I've represented him in the past, and it was $1.5 million, and he wanted to know what I thought of it. And it was on a regular NABOR contract. And I suggested, just psychologically, because I've seen this happen before, that if he goes to the NABOR as is and closes in 2 weeks, I mean, I've had clients really get a deal.
That's right.
I mean, we're in February.
Right.
You're not going to tie up the whole season. It's 2 weeks of the seller's life. We don't know if the seller needs the money for another purchase. But I said that this is one possibility. If you go as is, close in 2 weeks, you can still pull the plug when you get your inspection reports and if there's something that bothers you, but you may get a really good deal. And I had that with a property in Port Royal, and this goes way back to the first Persian Gulf War, where the property was listed for $6.5 million, owned by a German couple. My client offered $4.5 million, closed in 2 weeks. Actually, it closed in 3 days, and they took it. And I think there was some anxiety over the war. They just wanted to get their money out. And he got it for quite a bit under list. So there's always psychology, as you, the realtor, would know.
Yeah, there definitely is. Timing is everything, too.
Timing and how you play the game.
Yeah, how you play the game. Let's go into the other contracts that were regular contracts.
Well, if I were selling the property, me personally, and there's no right or wrong to this, it depends, my situation might be different than somebody else's. I like the FAR regular contract. Why? Because I like time is of the essence if I'm the seller. If the deposit's 1 day late, they breach the contract. If they're 1 day late on an inspection, too late.
Right.
There's no wiggle room there. The tangible property is shorter. There's less of it. I'm not giving away my stereo. I'm not giving away my home security system. I'm not giving away the washer and dryer under this contract. The inspection process I like better. There's no definition of mold or radon as a defective item. So I don't have to go through explaining to the other realtor how mold is a fact of life down here. It's part of your annual maintenance of your home. I don't have to deal with somebody's fear of a Latin-named spore, Penicillin aspergillus, by going through another agent who may not quite understand what I'm saying and hoping that agent relays it clearly to the buyer. So, and I like being able to sue for deposits made or agreed to be made if they want to walk away for the wrong reason. I like that being my liquidated damages that I can go after. And when you go further on into the contract, they have 3 categories in paragraph 9 of defective items. They have general repair items that defaults at 1.5%, wood destroying organisms, which is termites, 1.5%, and permits, 1.5%. So I can control how much I'm going to spend initially, and there's a whole psychology to that too. You put most of your money into general repair, a little bit in wood destroying organisms, and close to zero for permits. That's what I would do. That's my personal, I would know the history of my own house, so and I would disclose any situations that I know of. So I like things like that. I like, from the seller's perspective, that the financing clause is so incredibly scary to the buyer. The financing clause was changed last year, and it requires now that the buyer give notice of loan approval to the seller within the default period, whatever it might be. And if they don't give me notice of loan approval, they've waived it. So it turns into a cash transaction. Now, if I'm a seller, I'm hoping that they didn't read this too closely and that the agent is somebody new out of whatever real estate school they went to and missed it. And I also like that even if they give me notice of loan approval, I still have 2 days as the seller to terminate the contract, because the deposit might be too little and I might have had a lot of run-ins with the buyer over various inspection issues, and I just know they're a headache. I'm never going to make these people happy. I want to get rid of them and put it back on the market. It's February. I don't want to miss this season. So the financing, I think, favors the seller, at least in my opinion. So I would go for it for that reason. I also like the risk of loss paragraph if I'm a seller versus neighbor. Here, like with Hurricane Irma, if you own property in the estates and you lose a bunch of trees, like someone we were talking about before the show, here all the seller has to do is prune and remove the trees. Neighbor, you've got to replace the trees. Trees cost a lot of money.
That's right.
So it can be a huge, huge problem. I like the comprehensive riders. A is for condos, B is for homeowners associations. Those specifically deal with, among very many things, it's much more comprehensive. There's more you can do with it. You can control who assumes payments due on special assessments after the closing. And I like that sort of maneuverability, for want of a better word. I like that either one or both of the riders specifies that damages to the common elements, say from Irma, is not something to be considered for under the maintenance clause. That some buyer cannot hold up the closing because the association lost a lot of trees and there might be a special assessment for the trees. That's not a variable under this contract. So that in hindsight after the hurricane, I like as a seller.
Yeah, we've learned a lot.
Quite a bit.
Well, before you go into a little bit more here, let's just take a little short break and hear a little bit about the York team here in our commercial. Thank you.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Welcome back. Don, let's talk about mold and radon in the contracts.
In the FARBAR contract, again, if I'm the seller, it is not considered a general repair item, mold or radon. NABLE is the only contract I know of that has that. The test is not a test that was designed by scientists. It simply allows people to measure the spore count outside the structure versus inside the structure. Right. And that can be affected by atmospheric conditions and activity within the house. Both of them can be. So while I think the radon and mold tests are very valuable, I think people misconstrue them quite frequently. So as a seller, I like that mold and radon's out of the picture. I mean, they can do it if they use an as-is contract and raise it, but it's not there for a reason. There's no biologist who's going to come out and say this is the definitive test to tell you if a house is a sick house. I mean, there's no way to really tell if mold is inside a wall, for example. And I had this conversation this morning too. A home got damaged quite badly in the hurricane, needs a whole new roof. And we don't know how long the power was out. It was foreclosed and it's owned by a bank. So and there's stains in all the ceilings inside the house. So you got to think that possibly moisture got inside the walls, and because it's a foreclosure, possibly the power was out for a significant period of time. It doesn't take long. If it happened right after September 10th when Irma hit, it could be a real issue. It could be inside the walls. So I like, as a seller, that mold and radon is not considered a general repair item, and I don't have to explain, like I do almost every single day that I work, to clients from up north what mold is, why it's an issue down here. We're a semi-tropical climate. We live next to the Everglades, which is, I don't know how many millions of square miles, but it's huge. Most of the mold are allergenic. Some cause disease depending upon your physical situation. I mean, I'm allergic to cats. I'm allergic to peanuts. So I was allergic to ragweed living up in New England. We don't have it down here, so it's not a problem. But there are people who would be allergic to Penicillium aspergillus. It becomes subjective. So as a seller, I just thought it would be interesting to see, for people to see that there's no clear good contract for everybody. Right. There's no clear, this is best for sellers and this is best for buyers. It all depends. It depends on your health, it depends on your finances, it depends on your knowledge of the contract, depends on your agent's knowledge of the contract. It depends upon the price.
That's right.
You know, how much.
Maybe how new the property is.
I mean, I have actually drafted a lease on a napkin.
Mm-hmm.
You know, when one of my children was going to school in,
Right.
in Ireland, we wrote the lease on a napkin.
Mm-hmm.
You can write a contract on anything.
Right.
But if I'm constantly being asked which one of these is the best.
Mm-hmm.
And I don't know the buyer's financial situation. I don't know the buyer's health situation. I don't know the seller's financial situation. I don't know if they really, I don't know how knowledgeable they are. I mean, it's hard, particularly when I'm dealing with other attorneys, because I don't want to preach to somebody in my profession. I mean, they might know this better than I do, for all I know.
Right.
And I always apologize, saying I don't mean to preach to you. I mean, I just did a closing with a Chicago attorney. He bought a place on Marco Island, a very expensive condo. I said, "You tell me if you already know this. I don't want to preach, but this is how it works down here. You know, you're up in Chicago. It's a different form contract. If you're in New York, the attorneys draft the contract. If you're in Massachusetts, you have an offer sheet and then the P&S. So everybody does it differently,
Mm-hmm.
and you don't want to offend people. So I thought it'd be interesting, and actually my wife concurred, so it's obviously correct,
Right.
that to explain, we have 4 contracts. You got the neighbor standard contract, you get the neighbor as is. They have different lists of personal property that go with the property.
Mm-hmm.
You have different rules on timing. You have different rules on the deposits. The time is of the essence. Different rules on mold. You got different rules on what's included and what's not included, washing machines and so forth.
That's right.
And just to show by way of example, if I was selling my home, oh heck, you know, my choice would be the FAR standard contract, because there's just so much I can do with it. But you
Right.
got to study it to really know what you can do with
That's
it.
right.
If I were buying, and I've done this with my children,
Yeah.
use this one.
Right.
I know you use it with your children. I
That's
know
right.
you do. So I've seen the contracts. So
So,
you want them to be safe.
Yep.
So
well, thanks, Don. I think we've covered a lot today. I know these contracts are really written by attorneys, so it can get a little complicated, and a lot of people don't take the time to explain them or even to understand them and study them, because there's a lot, and you're jeopardizing, or person's buying whatever, $100,000 home or $1 million home. It can make a difference.
And I don't want people to walk away from this show thinking Don says this is
Right.
best for
That's
sellers
right.
and this
No.
is best for
You're
buyers.
just explaining the differences.
This
Right.
is why it'd be best for me.
That's right.
It would differ for you or for anyone else depending upon your situation, your health, and so forth.
That's right.
A lot of moving parts.
A lot of moving parts.
A lot of moving parts.
Well, thanks for coming in. And
Thank you for having
thank
me,
you for
Jim.
tuning in, and we'll see you next month. Thank you.